Assalamualaikum. Tak ada. Assalamualaikum, Datuk.
Salam, Doktor.
Ya, Nim. Thank you for coming. Sempat sampai rumah, Datuk?
30 minutes ago, Tok. Encik Sami, Encik 30 minutes ago, Prof. Pening kepala dah.
Apa dia?
30 minit lepas. Baru
Oh,
dapat
okey.
letih betul lah.
Ada letih ya. Saya balik PD kan?
Balik PD. 7:30 in the morning arrive office. Sekarang baru sampai. 30 minutes ago.
Betul. Yang ni dah baca dah?
Dah baca dah, tapi a bit perplexed to understand. A bit perplexed to understand.
Memang lah.
Yang I tahu is Roscoe Pound, of course. He's talking about social engineering, but through law. And then he talks about the strong judge who knows how to use the percept of law is to advance justice. Lepas tu, he talks also about problem with judgment is that there's a struggle between first and they're talking about law and to ensure promotion of justice. At the same time, they kena buat also judicial decision
analysis.
So that's why analysis. So that's why kadang-kadang dia ambil level on judgment lah, some of them lah. Lepas tu talking about a species with resultant belief that all human beings pure regard to blah 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 to some norm standard apa tu, but in general the issue is more related to must be guided when courts have perceived what is it that they are doing so that they can change themselves consciously for the betterment of the society lah. So in other words, it's the same thing as American legalism lah in general.
So I think judges everywhere in this world, they are facing the same problem. If the legal system is on common law, even bigger lah the responsibility, right? So they are, they wanted to produce justice, but at the same time they have to also look at the law. They cannot be going beyond the law. They have to abide to the precedent, you know, and obviously knowing about the law, and then knowing how to apply the law, and then the effects of the decision that they make. Is it something that is going to have a lasting negative impact or a positive impact? So all those things are intertwined with a function of a judge. And then on top of that, there are many variants of sources that they can or they are expected to find solution from. Say for example, the law, dengan the law sendiri dah ada conflicting, you know. And then on top of that, if the law does not provide some solution, then they have to investigate and look at other means of sources. So for example, macam kita ada Islamic law, you know, in order for them to make the decision, it has to be balanced. Kita ada traditional or what they call it, custom,
Legal pluralism lah.
culture. Legal pluralism is something that is real, something that the judge, if you end up as a judge, obviously you are bound to this type of dilemma. And this is what he is trying to say, because the jargon or the complication of the legal, what do you call it, the legal system that we have is something that is taxing. And yeah, you really need to know what you are doing, right? So as far as theories of the judge is concerned, of how they are to do their justice, to deliver the justice, is very technical. It is very you cannot simply, macam dia cakap kan, you cannot use the comparative to compare with doctors. Doctors memanglah dia ada penyakit kan,
Ah,
penyakit, tapi penyakit pun dia kata normally they would go along the line of certain penyakit yang dia orang boleh tahu, you know.
ini
Obviously
abstract.
penyakit pun tak banyak. Macam mana?
Ini judges using abstract, not like
Abstracts.
doctors. Yeah.
Uh, uh. Then at the same time, they are to utilize the tools. The tools are the laws.
So
Within the laws itself pun dia ada banyak lagi kan.
within the law
So
pun
many
dia
things
punya,
that they have to take into consideration. So which one is right? Which judges yang apply to that particular law is something that is being expected to result in justice. So banyak benda yang dia orang the problem lah that they are facing.
penat lah.
Penat.
Banyak sangat.
Tapi memanglah kalau baca, it takes time lah in order for us uh, to to understand what he is trying to say. But there basically ada dua part. One is the problem that is being faced, the reality of a judge in order for them to come up with to come up with their decision. That's number one. And number two is the part whereby the application of theories, which theories that they want to choose in order for them to come up with that decision. Kalau yang ni bagus lah, kita nak baca sekali tu, saya rasa susah sikit lah, because jargon yang dia pakai, and then the wordings kan, it's quite difficult lah. Dia orang ni, a simple thing, they make it so difficult for us to understand.
Understand. Betul.
Aduh. Dia banyak berbahasa macam mana? Macam
Bunga-bunga, flowery,
puisi.
flowery. Yeah.
Puisi. Go straight to the point lah. Kita nak faham kan. Bagilah example. Ni example yang dia bagi tu is something towards that. If you are familiar with that argument lah. Hi everyone. Okay. So kalau nak betul-betul faham this area of the topic that we are supposed to cover today is by reading this. So you baca at least 3 kali in order for you to understand what he is trying to say. So dia ada dua part. Satu is on the judges punya difficulties that they are facing, and the solution yang dia propose. Sebab dia propose social engineering kan. So that is the two part within the article itself. Anyone wants to ask any question pertaining to the article? Saya record je ni ya. Ada tak soalan? Rasa kalau tak baca memang susah lah. Cuba baca, try to read a number of times insyaAllah, because it relates to the discussion dalam exam. Kalau lah soalan ni naik, when it comes to judges, the problem that is being faced, so that is something yang hari ni kita akan go through. kita akan go through the slides dulu lah, the topic ya. So takut buang masa, now 9-7 minutes lah. So kita tengok kalau judiciary ni, this slide you will see word cloud lah, we call it word cloud. And obviously from looking at the things that is mentioned, talking about government, politics, doctrine, function, economic, legislature, all these are the orang kata makanan judiciary lah, because whenever they make any decision, it's going to have an impact, whether it is positive or negative, whether it is towards the whole nation itself, right? So they are, as you know, they are the guardians of the country. Okay, one of the three important organ yang kita establish under our federal constitution, the as the legislative, judiciary, judicial branch. So they, nama pun judiciary, they are to judge in the other two punya function, which is legislative dengan executive. If anything that is going on with the legislative and executive, then they have to come in order to make sure that there is no Hitler that is going to be the one yang kita tengok macam recently kita tengok what happened to Sri Lanka, you know. So those are the things that is happening globally, that you can see the judiciary is not functioning well. They do not dare to go and go against the executive and legislative. So that is the function of the judiciary, other than to resolve the problem of the society. So we are looking at the perspective of how judiciary has to function. So what that got to do with jurisprudence, because they are the makers of the laws, or they are the one that is the guardian towards the law. So we have to look at them in order for us to understand the relevance of our the law that we have in our country. So kita dalam ni saya akan bahagi dua, judicial process dengan judicial lawmaking. We look at the theory itself, and then we look at the role of the judiciary. So if you are the judge, obviously you are bound to some legal concept, legal thing, or legal administrators. You as the administrators, obviously you are bound to a certain process or certain system, that is binding the judiciary. And then on top of that, you are to utilize the various theories of adjudication that you are made aware of. Macam sekarang kita belajar Juris 1 and Juris 2. Those are the principle of theories that is open to you in order for you to have your grounding before you make your decision. Because it's very difficult for you to make a decision without having a legal footing ataupun a legal theory that you are basing your decision on. So we are looking at any judges from now on, especially those judges yang duduk dekat atas tu, dekat apa orang kata, dekat appellate court apa semua kan. We are looking at those people especially because they are not really bound by the law. They more towards justice. Rather than the what they call it, the nitty-gritty of the law. Looking at the lower courts kan, lower courts tak banyak chance untuk dia orang to play around. The role of judiciary, as I already mentioned, is the function of the judiciary. How are they to perform in a nation? So we are going to look at that. So there's two parts lah. So judicial process, justice is something that is very important in our Commonwealth system that we adopt, because that is where you want to create the balance, right? Whether someone is to be given or kita nak dapat justice tu hanya dengan guna courts lah ya. So other type of justice memang susah lah kalau kita nak tengok. Every other people, they have some some factors that is influencing them, especially when you talk about politician. You know, they have their what they call it, their self-interest. And if you look at executive, they have their own means of looking at things, which they think that is right, but doesn't mean a right, you know, is actually something that is fair, that is just, you know. Uh, so we are, that is the apa, important of the judiciary in with respect to akta that we rely on. The legislature buat akta, and then it's being used by executive in order for them to do their job, right? To administer the nation. An act is normally having function or situation whereby it is not perfect, okay? So you know, from learning law, then the laws or the akta that we have memang akan ada some imperfection. Kita pegang kepada ciptaan manusia ni tak akan perfect macam dengan ciptaan Tuhan lah, Allah. So kalau kita tengok the first one, theory of adjudication. So I letak dia ni, Datuk kata, oh ya, ada Star Wars pula. So kalau tengok Star Wars, the movie itself, ataupun you tengok mana-mana movie, dia mesti ada ground theory yang dia pegang. Okay, mana-mana movie kalau you tengok, if you pause kejap, you have that apa, critical analysis. You look at any movie, dia mesti ada dia punya theory, you know. Kalau kita tengok Star Wars, theory dia is something that is basing on the fight between the right and the wrong, yeah, to in order for you to create justice for the society. It's a fight between two polar distances, or polarized punya situation where the right and the wrong. Okay, so for us, in order for us to understand law, we have to rethink about what we have learned, and then we utilize the theory yang kita belajar, and then the theory make sense of the law yang kita dah belajar. Okay. Sekejap, okay. So if you're looking at Star Wars, kalau you tengok, check the basis of the theory behind Star Wars. But the thing is, we have to understand the theories or something that behind apa yang kita belajar. So, yalah, you belajar macam-macam kan. Daripada macam-macam tu sebenarnya, you jumpa so many decision, court decision. So, you kena analyse the role of the judge within that decision of that particular case. Kenapa dia buat macam tu? Kenapa dia the decision that is being made? Dia tak akan cerita, okay, saya akan pakai natural law, saya akan pakai civic ni, saya akan pakai Roscoe Pound, saya akan pakai. They do not do that. But if you read between the lines, insyaAllah you akan nampak the basis of their decision that they are making. So macam biasa kalau you tengok Star Wars, the Death Star tu memang very powerful. Obviously the Death Star is replacing macam Akta lah. Akta is very powerful tools in order for us to provide justice. But sometimes you can see Death Star is something that is vulnerable, yeah, something that is having lacuna. So the same thing that happens in the Death Star punya situation, because they work hard towards destroying the Death Star. So the same thing dengan kita punya akta. So akta kita ada banyak loopholes, and this loopholes is being utilized by people who understand the law in order for them to win, you know. So the judge is sitting right in the middle of the situation where they have to whether they want to allow that kind of vulnerability being used by people, or in this case lawyers lah, yeah. So it is very difficult for them to ensure that to make it proper. for it not to be misused. So we have this Gloria Steinem. She is saying that law and justice are not always the same, right? Because as I mentioned, kalau you tengok in this you tengok the article itself, it is talking about law and justice. So here, law and justice are not always the same. When they aren't, meaning they cannot be together, they are supposed to be together. Destroying the law will be the first step of changing it. When you can see ISA. ISA is a clear example that I can give to you that ialah you semua orang tahu kan what happened dengan ISA. It is being utilized by the executive in order for them to get their aim. Whether the aim is ramai tak boleh masuk. Oh, sekejap. Oh, dia tak bunyi. Okay, my wife baca you all punya message. Kena bagi tahu kawan-kawan. Siapa boleh masuk, tak boleh masuk. Alright. So kalau ISA as an example, kita akan nampak ISA punya injustice that it brings about. Orang kena tangkap malam-malam, kena pecah rumah, and then people don't tell why they are being captured, and then they were not presented to the court, and they were imprisoned at the location yang memang memang kita dengar pun macam okay, but it happens, and then it was initially good law, but it was misused by the executive where it produced injustice. So the first thing that we have to do is to make sure that we have the law removed. So the action of the judge with respect to this so-called idea that if they saw, if they were to look at the law itself yang memang unjust, what they are supposed to do is to incline their decision towards trying not to accept ataupun to acknowledge that kind of law. Because kalau acknowledge that kind of law, bila diorang at the judges punya level, if they were to make any decision that assist this injustice, then it becomes precedent, and dia macam seolah-olah mengikat diri mereka sendiri. You know, you have the power in order for you to change the situation, but yet if you do it in a way that you don't know what you're doing, and then at the same time you ada political inclination towards the government, this, and then on top of that you are bound by that law, itu jadi susah, jadi susah untuk dia orang nak survive. As dia tak bunyi lah orang nak masuk ni. Can you be aware of siapa-siapa nak masuk? Can you let me know? Kat I tak nampak tau. So dia selalu bunyi ada orang nak masuk. Right. So as usual, stop me whenever you have problem of understanding. Itu biasa. Kalau kita tengok undang-undang, it's not perfect. Something that we have to, when we say we are the people of law lah. Kalau lah kata we the people of law in the position that we are able to change the law, then we have to do something. Okay, so as you have learned from Juris 1 and Juris 2, ada prescriptive, theory, and ada yang descriptive, ada yang normative. Prescriptive is macam the East punya group lah ya. So the East punya group is to prescribe, meaning you don't have any way for you to say something else. Cuma dia kata it is what it is. The law is the law. So you tak boleh nak argue sangat. So judges kalau dia ambil prescriptive, dia punya inclination is to just follow the law. Okay, or whatever the statute says, dia akan follow the law lah. It's quite a simple and easy job. But that is if you are a prescriptive point of view. And then kalau descriptive, kita dah belajar descriptive to describe, meaning kalau kita tengok natural law, Juris 1 kan, It is about being able to decide what is the law, what is the function of the law, what is the purpose of the law, what the law should be. You know, ini geng-geng yang odd, ya, descriptive is odd. So prescriptive, descriptive kita dah belajar. Benda tu, I think you still can remember those people, juris yang juris 1. Now, normative is something that is being normalized ataupun being, you know, is a norma hidup. Norma is something that is based on reality of the society. So normative is more towards juris tu lah, where we have the approach of normative punya teoris yang kita dah belajar. Kita belajar Roskopang, kita belajar American, kita ada Scandinavian, kita ada feminist, kita ada Marxist, ya. Kita ada postmodern. These are normative. Normative kerana it is something that is being absorbed ataupun embraced by the society itself. It becomes normalized. Okay. So sini dia kata conceptual category that distinctly aduh susah kadang-kadang syashul ni. So what this macam kita tengoklah the problem of the judges untuk nak decide the cases, you know, something that is very, ada banyak factors that they have to look at. So kalau kita tengok abortion punya situation, Roe and Wade, and then we have now the current decision in the US overturning Roe and Wade. So it has a very great impact towards the society, towards the nation itself. So we have apa orang kata, we have states yang go against, and then we have the states that already changed their law that meets the requirement of Roe and Wade. So these are the things that is happening when it comes to judges. You know, the core role play ataupun the core object of our application of the law is based on the judges itself. Okay. So I think I already mentioned that earlier on. Kalau you baca ni kan nampak. So we have to study the courts and judges because they are people like you and me, but they are more well versed in terms of the law. So memang susah pun nak jadi judge because you're being pressured by your KPI, you're being pressured to not to, orang kata tak boleh nak tidur malam because you have your conscience to be free. So my wife sebagai lawyer balik pun nangis-nangis, saya kata berhenti je lah because so many things that is happening, injustice, you know, that you cannot bear. So can you imagine judges as their profession untuk nak buat decision, and the expectation, knowledge yang dia orang kena ada, the expertise yang dia orang kena deliver, and then not to make any wrongs. Kalau you buat wrongs, you come up with a decision, you akan kena belasah dengan your colleagues, and then have the response from the society looking at your decision. Ingat tak yang Datin tu yang dia pukul dia punya mate tu? She was she got a lesser sentence kan. So it is apa apa nama kes tadi tak ingat. Ada tak? Datuk ingat?
Lupa, tapi dia dapat fine ke apa something like that. Lepas tu dia
dia cuma dapat fine kan, not jail. So those are the things yang memang problem to judges lah. Okay, especially kalau kita tengok sini ni, democracy, you know, and then at the same time separation of power punya role yang saya cakap tadi lah. Okay, dia kata kat sini 9.30 lah. So it is a far-reaching punya implication lah for the legislator, administrators dengan lower courts, because any decision that is being made by the upper courts, kan, you all pun tahulah, you belajar semua paper-paper kan, land law, contract, I've given you example Sri Lempah lah, macam Thoughts punya decision, Donahue, Stevenson, kita ada apa, Fufiona punya case, Stephen Poor punya case, then you belajar criminal law, so many cases, the landmark cases where they set the precedent. So when they set the precedent, then obviously it has the far-reaching implication towards legislature. Ada kalau Mamat bin Daud, they go to that Techempo punya case. The job of the courts is to make sure that justice is to be served. So they go beyond beyond the letters of the law in order for them to get justice to the society. Okay, so dia kata this manifestations of the judicial power seems to go beyond what is the relevant constitutional provision required. So they have to, federal constitution is just a book. It's just a book that comprises of basic laws, right? So it is so tiny and it does not able to provide us with the way out for us to get justice. It provides the foundation of justice, but not actual deliverance of justice. So jadi nak translate daripada federal constitution to delivery of justice, there are so many things that they have to consider in between. So obviously some people are not happy with the evolution where you can see in the next second part, di mana kerajaan, especially the executive and the legislature, don't like the legislative, the judiciary. Right. Socio-political theories are concerned with causes of judicial behavior. So because they are there in order for them to make decision, obviously they have the responsibility untuk nak buat betul. They have to be right. Because as I said, kalau they are not making good decision, it is going to be problem for the lower courts and then problem for the nation itself to implement what they, macam kita tengok the Roe and Wade punya situation now, because of the inclination towards pro life rather than pro choice, jadi it is going to be a big issue. It is a big issue. Okay. So independent variables, meaning there are so many factors that is going to impact the decision of the judge. So these are the things that we have to look into in order for us to understand the behavior of the judge, in order for us to understand why they are making that kind of decision. Obviously, this one goes without saying kan, kita dah belajar harus propound. Social engineering is his way out in order for the judges to apply his method. If we can change the mentality of the judge to have a clear clear projection of the impact of their decision, that would be the best lah. Because bukan setakat jargon di mana judge tu nak kena belajar undang-undang. I know you might be thinking that apa yang susah sangat kan, because the parties are going to present the case, right? But the judge, in order for him or her to make the decision, they have to know the law first. And then on top of that, they have to know bigger than that, not only the law that has been presented by the parties, but they have to know everywhere, everywhere else that is possible for them to know of in order for them to make decision. So prosesnya memang rumit lah. On top of that, terus kamu kata, you have to look forward, look at the society. Kalau you buat decision yang silap, it is going to impact the society for maybe 5 years, 10 years, or 15 years before it is being overruled by another similar jurisdiction. So rather than doing orang kata setiap apa to let the machine tak jalan, so what you need to do is to do the balancing that you need to do before you provide the outcome. So social engineering, Tamanaha, it is looking at the holistic vision of the law. So kita tak boleh nak kata one law fit all. Tak boleh, it doesn't make sense. You cannot force a law towards some group of people without looking at the overall implication of the law. Kita kena tengok dari segi social, cultural, economic, political, ecological, technological, ataupun environmental. Those things that that we have to look at because they're dynamic, they're holistic dynamic. It can go anywhere. So he challenged the mirror thesis. Ini kalau I berjaya dekat my country, then it should be applied to other state also. It doesn't work. Mirror thesis dia kata memang susah lah. Legal transplantation, it does not work. Kalau kita nak transplant, ambil satu pokok, nak bubur kat tempat yang lain tanpa kita tengok keadaan tanah, keadaan matahari, it doesn't work. It doesn't work. Kamaks, sorry laju sikit. Kamaks pula, as you know, they try to make us understand, meaning make the judges understand. Mungkin bila kata make us understand, make the judges understand that their position is actually within the position of the pyramid, and they should not be within the pyramid itself. They have to go out from the pyramid of being dominated by the bourgeoisie. So judges are proletariat. They are the one that is being used by the system. So if you are able to understand that, obviously you are able to make a decision that is more realistic towards the society. So macam ni lah kalau kita tengok tu judge judge, priest, people of high ranking, barons ke apa ke, they are the one that is utilizing or being used by the system. Okay, right. Weber, kalau kita tengok Weber, it is more of anti-positivist punya approach because he likes to have a more more realistic more realistic toward the society. So you have to interpret rather than be in a empiricist means. Then if you go along that line, interpretative, because you have to study more, you have to evaluate, you have to investigate, you have to decipher so many things in order for you to understand the problem at hand. So if you are a judge, utilizing Weber is a means for you to have a ground, a ground, a good foundation in order for you to make a decision. So obviously he is talking about labor. Weber kan, he looks at the society, and the main thing about the society is work, and work is the core of the society, right? So if work, then obviously it is being utilized between the owners of the workers and the workers themselves. So he sees it as monopolizing the advantages of the capitalists, not to say capitalists, but the stronger body, which is the employer, in order to utilize labor. Okay, you know what seems to be the problem of labor even today. Thousands and thousands of people are stranded because of the COVID punya situation. After COVID, they want to travel everywhere. Now they are facing where not enough managers, not enough staff to handle the traffic of tourists. So backlog of thousands of people. So basically it is about labor. It because bila I tengok Al Jazeera, I think tadi kot, they were saying that the core problem is when they throw these people out during COVID kan, obviously, then suddenly you have a boom where everyone have money, save up nak pergi holiday, tiba-tiba tak ada kerja. When they ask these people to come back, people will say enough is enough. We don't want to come back to work. So this is happening throughout the world. They say that the great resignation. Everyone wants to resign because they think that they are able to find happiness in a working environment yang better suit them rather than being forced by people. Nowadays pun dah ada 4 hari seminggu bekerja. It is good. The productivity went up because people are happy. They have more time. Walaupun gaji tak naik, tapi they are more happy and the productivity is going up. So I hope yalah, tak tahulah bila yang kita nak pakai 4 hari tu. Okay. So basically kalau kita tengok American realism, then obviously you talk about the reality of the situation. Who is in power to make the decision in that particular case? So here we are talking about the judges. They know what they are doing. They are they are there to know what they are doing, right? So Batman theory, obviously, Holmes says that they are very focused to get the problem resolved, and the way that they wanted to do it as kalau dia nampak facts tu, dia akan nampak the decision is already in their mind. Okay, they just want to deliver the decision, and they will take all the laws that is needed for them to come up with that decision. Okay, I think Datuk, you perasan bila you pergi dekat federal court, the application of the judges is very straightforward. They apply the principle of natural justice, and they know because they are the one that have made the decision before you enter into the court. They already make decision whether you are going to win or lose the case. Okay, paper rules. Llewellyn talks about what is real rules, what is paper rules. We have to differentiate. Judges have to do that. They have to really understand what is paper rules, what is real rules, in order for them to give up their decision. Then we have Jerome Frank talking about the pyramid, where you are to look at, then you will see the situation of the judges. If they were to be on the skeptic of the rule, they are skeptic over the facts. So this is a balance that judges have to go through every day in their line of job. Okay, think this one just to give you basis of theories that you will apa orang kata, you akan pakai dalam you punya examination question kalau ada. Then you should be able to look at the problem yang, kalau lah soalan bagi problem, then you are to look at the problem and give your own analysis as if you are the judge, right? Tapi at the same time you kena bagilah situation whereby it is something where they have to do something other than they have to think outside the box. Okay, John Rawls, you dah familiar dengan John Rawls kan? Apa jadi dekat sana, theory of justice, where you have to be not selfish. Kita kebanyakan ni manusia ni, kita fikir tentang diri kita je. Kita tak tengok orang lain, dan kita kita rasa kita bertuah kan, tapi sebenarnya kalau kita betul-betul rasa bertuah, you should be able to look at the imbalances yang kita ada dalam masyarakat. Dengan realizing kita duduk di bawah orang kata a blanket that is binding us from looking the reality of the society, itu akan menjadikan kita tak boleh maju. Negara tak boleh maju apabila kita tak sedar di mana imbalances yang berlaku dalam negara. So as far as judge is concerned, dia kena tengok the same thing lah. Kalau dah kata dia kena look at the imbalances yang berlaku dalam case dia. So imbalances yang berlaku dalam masyarakat, macam mana? Dia adalah salah satu organ yang penting, as I mentioned, separation of power kan, untuk mengubah masyarakat. So in a way that you have to do that as a judge, tu nak cari equilibrium yang sebenar. Kelson very straightforward, ini preskriptifnya base kan. So kalau preskriptif, it's more about the legal norm rather than looking at the law itself. So legal norm is a scientific method untuk kita nak cari the basic norm. Ya, kita tengok the legal norm obviously is the lower part of the pyramid, and you work yourself up in order for you to understand what is the basic norm of the society. So as a judge, you kena look into that perspective also. Kalau you pakai legal norm punya Kelson punya teori lah. So kalau kita tengok the primary norms, secondary norms, and then kita ada the enabling act, kita akan sampai ke basic norm, which is what is the total. Can you imagine that the judge have to understand from apa orang kata polis yang duduk dekat dalam kereta yang polis Honda, say for example, the whole process that is involved. Kalau ada accident, siapa yang involved, insurance ke, plaintiff, defendant, lagi the police, and then whoever else that is within the judiciary, all they are involved in the what they call it, the legal norm. So daripada legal norm tu kita investigate kuasa, punca kuasa, dan kita akan nampak ground norm. So judges have to know this, judges have to be aware. Walaupun kes tu kes kecil, kata abuse of police power, dia kena investigate in total. So dia kena nampak perspektif dia in a very wide angle. Okay, now I think we have another 15 minutes to go. Theory of adjudication nampak macam mana? Ada soalan? Ada tak? Guys, ada ke tak ada?
Okay, Prof. Okay.
Okay. So to recap, teori, teori adalah sebagai salah satu tools yang digunakan oleh judges untuk mendatangkan keputusan dalam kes mahkamah. So yang kedua kita tak tengok role dia. Itu role yang pertama ialah untuk banyaklah role dia sebenarnya, tapi one of the roles to look at the theory. Second is about the role that they play in the separation of power yang kita ada dalam negara, di mana yang ni saya ambil 1986 punya Tun Mahathir punya statement. Kita although you pass the law, meaning the legislative with a certain thing in mind, because you debate in the legislative process, so you have something that you wanted to do, but the court says that no, I don't think that what you are looking at or the one that you create is wrong, and therefore we, the judges, will give our interpretation towards the law. So banyaklah yang berlaku waktu waktu 1986 recession, kita ada political punya apa orang panggil Datuk? Political
kuli UMNO ya.
Kuli lah, UMNO lah, UMNO 46 lah, and then UMNO declared as null and void. So many things that is happening back then. Then we have the Operasi Lalang, And those are the things that the government is very pissed off lah dengan the judiciary, leading to the extent macam ni, even Shad pun mengaku there are certain things within the constitution itself that have lacuna, where it can be used towards the imbalances ataupun injustice uh, towards the society. Okay. Then kita tengok ni Tony Fernandez. Apa nama? Lupa dah. Apa? Tommy Thomas So yeah, so talking about separation of power, the importance of the judiciary to play their role untuk nak balance the society or the nation itself. So which leads to macam ni saya ambil Teh Cempoh punya case. We don't want cases to go to Privy Council anymore. So somehow it was stopped during this time, 1980s. 1980s macam tu lah. Right? It was removed. We don't want to refer to UK because it brings some lots of problem lah to the administrator ataupun the executive. Okay, this is relating to the case of Tachempo. I think you already know about this, right? And then the decision together with the escape punya situation, and then the assault towards the judiciary by the government. Mahathir doesn't want to admit that he was the mastermind. I think he is the person yang memang go all out untuk get what he wants. I was told bila Kedah punya member of parliament, member of what they call it, DUN. So he for them, and in front of him dia kata ni ada file you, I tak tahu apa yang ada kat dalam file ni. I think you have to rethink what you dia macam gangster jugalah ya. But that leads to a situation of Tun Saleh Abbas, Tan Sri Azmi Kamuddin, Yusof Abdul Kadir, this when they go against the decision of the government towards Saleh Abbas, they will also take an action against. And kalau kita tengok Dewan Nordin Saleh punya situation, so many cases that occurs, that is landmark cases with regards to the authority of the judges. So the question is, when judges goes to play their role, especially when they are at the higher courts ataupun the pinnacle of the system, then they have to do something. If they were to have something wrong that they have seen, then obviously they will put their foot down and try to change. Yeah. So we have controversy of the usage of nama Allah. Those are the cases. So sini kita panggil judicial activism. So one part of your answer, if you want to look at the role of judges, then obviously how far that the judges have to perform their duties. Is it something that is in line with judicial activism, where they can not worry about their position, okay? Then they are able to go against the executive and the legislative, even the Yang di-Pertuan Agong. So you have been exposed to cases that relates to the role of the judiciary in order for them to bring about justice. Okay, so that's it about judiciary. So do you have any questions that you want to ask? Dia ambil semua. Ada soalan? Soalan exam tak di-share dengan saya lah. Saya pun tak tahu apa. Tapi Datuk kata 3 topik yang terakhir Datuk.
Macam tu dah, Prof.
So katanya lah tapi kalau 3 yang terakhir ni memang favourite lah. Meaning this one is walaupun chances of question coming out dalam judicial punya judicial process atau judicial theory ni, tapi dia more relax because you boleh ambil mana-mana yang you dah belajar sebelum ni. Maksudnya dalam syllabus lah. Jangan ambil try to avoid Juris 1 punya syllabus. Though it is part and parcel of their proses untuk dia nak buat keputusan. Kadang-kadang dia jadi positivist, kadang-kadang dia naturalist, natural law. We don't want to concentrate. Selagi you bawa masuk banyak sangat dalam you punya answer dari caca merba. So you have to limit yourself to only the syllabus yang Juris 2 sahaja. Right? So sebab kita belajar juris tu kan, jadi kita kena limit our answers towards juris tu lah. Okay, and tu satu, and then postmodern dengan feminism. Feminism tu lagi satu dia Datuk.
Postmodern ke?
Postmodern simple. Have a mask kan. So have a mask, nampak the simplicity of dia punya decision or model untuk dia kata kita kena play, to be able to have public sphere and then communicative theory. So that nature lah, simple, you boleh goreng kan tu. And then feminism ni jaga-jaga sikit. Feminism kalau dia bagi problem, what you have to do is see in the perspective of feminist. Ramai yang lari dia jadi macam cakap pasal agama, it's wrong, which is something that you are not supposed to do. So what you need to do is looking at the 4 branch of feminist untuk you apply each one. So so macam mana? Ada soalan? Guys?
29 exam
29 exam, insyaAllah. You will get, I tengah nak siapkan yang punya karimak kena masuk hospital ni pula, kacau 3-4 hari.
Apa bagi semua 60 Prof? Bagi semua 60.
Mampu saya. Tapi insyaAllah lah, it is going to be in that nature lah kan. Dalam dia dah submit. Kalau submit tu dah memang pass lah. Kan? The problem is not submitting. So whenever you submit, obviously if you're talking about 30 over 30, right? So 20 dah dalam tangan lah. Takkanlah you hantar balik kosong tanpa tulis apa-apa. So kalau hantar balik kosong pun dah dapat berapa, 10, 15. Kosong maksudnya adalah sikit. Tapi tak perlu, tak sepanjang mana yang sepatutnya kan. So insyaAllah lah 20 lebih tu dalam tangan lah. Right. Soalan? Ada lagi? So recording saya akan ambil sebab dapat pula chance untuk nak record ni. So I will pass it over for those yang rasa saya laju sangat nak go back to understand this topic. Saya akan bagi link lah untuk you can do that. Soalan? Tak ada?
Tak ada, sir.
Tak ada ya?
Tak ada, doktor.
So don't worry, exam jangan takut. You ada foundation. Kalau dah ada foundation, you are there already. Okay. Dia sebenarnya bukan kita cut and paste yang saya look forward to. It is your own writing. Your own writing tu tak perlu bombastic English pun. It's just something yang saya boleh faham. Okay, kalau your English is good, then it's okay lah. Tapi kalau English kita ni orang Melayu kan, English kita semua tak berapa bagus. Macam datuk lain lah kalau dia dah dibesarkan dalam environment yang English kan. Tapi I don't expect that. I don't expect you to bagi nak tunjuk kecanggihan English tu. Saya nak tengok kefahaman you tentang apa yang you nak sampaikan. Itu je yang penting. So bila saya baca, saya akan nampak dan saya akan bagi markah. The problem is kita ada banyak candidates yang kita nak kena check within a few days. What you can help me is that you highlight. Okay, you highlight macam ni you tengok dalam slide the row of judiciary highlighted in yellow. So you highlight certain points yang you rasa you nak markah diberi nama dua type of apa orang kata tiga lah tiga type of color. One is the keyword of the teori yang you nak sampaikan. Satu lagi another color untuk the jurists themselves, and then the third one kalau you nak present example of a case, so you highlight the case lah. Kalau you jenis yang tak suka letak color-color banyak kan, so what you can do is underline, so that is good enough, ataupun bold, you know, bagi you punya write up tu stand out. So bila stand out senang, kita dah go through je. Saya tak baca pun kadang-kadang, saya tengok points je. Kalau ada ke tak ada, ada ke tak ada. So sambil saya glance tu saya tahu sama ada you faham atau tak faham. Kalau you cut and paste, memang obvious you akan nampak macam janggal lah. You akan nampak pelik lah, because the choice of words ataupun the connectivity of the phrases between paragraph and paragraph, dia akan nampak lari. So try to avoid that. Jangan menunjukkan kelemahan you. You buat simple, tapi as long as it is something yang boleh I nampak macam oh bagus, dia faham dalam kelas, dia dah faham sampai to the extent that dia boleh jawab exam. Okay, I will give you marks. And then panjang is not something that as a rule. So lagi panjang lagi banyak markah you dapat. No, because the tendency is that kalau you nak jadi panjang, so you akan cut and paste from somewhere, which is not important. Okay, and then lagi satu, kalau you nak explain about the person ataupun the jurist themselves, you jangan panjang sangat, because yang penting adalah application, yang penting adalah discussion. Okay, discussion tu maksudnya you kena compare and contrast, you bagi cases untuk nak huraikan, you boleh kata cases ni menunjukkan betapa teruknya this decision. So ayat-ayat macam tu akan impress me with your understanding of the question. Dia level kita ni level di mana kita dah faham about the law. You're not talking about understanding about the law. It is, kita dah faham dah, kita dah belajar dah semua semua subjek-subjek yang contract, tort, criminal law, constitutional law. So kita ambil dan letak. Dan jangan sekali-kali, ni try to avoid, jangan sekali-kali jawab seolah-olah jawab constitutional law punya paper. Memang salah. Okay, ramai yang saya terpaksa pangkah terus satu page. Sebab tak ada relevance. Dia bawa problem yang diberi dalam soalan, dia try jawab dalam bentuk constitutional law punya approach. Okay, fundamental rights lah, itulah ini. No. You are wrong altogether. Saya tak boleh nak bagi markah in that sense. Okay, there are situation where final over 40 dapat cuma 10 ke 13. Saya terpaksa cancel. Dia akan pass sebab carry mark dia tinggi, you know. Tapi that is not what you want. You want something that is alang-alang dah satu semester berkecimpuh I don't know what is the term. You dah involve yourself with this paper, might as well get high marks, which I am willing to give. Cumanya you kena be what as I said lah, apa yang saya cakap tadi tu is very important, and not to repeat mistakes lah. Jangan sekali-kali bagi you punya teori. Don't rely on your theory untuk nak masuk dalam exam. Jangan sekali-kali. So kalau in my thinking of this particular problem should be resolved in this particular way, habis. I have to pangkah. What you need to do is to be able to say from the perspective of Roscoe Pound, which he mentioned about the balancing of interest between private, social, and the public. That I think the Roscoe Pound view is better as compared to American realism. Boleh, yang tu okay. Itu tak ada masalah. You are critical about your analysis of the issue at hand. Tapi jangan sekali-kali keluarkan dia punya teori. Okay. Islamic, especially on the Islamic part. Syllabus ni tak ada Islamic. So juris one ada Islamic. So don't bring in your Islamic punya understanding ataupun teori. Okay guys, boleh? Ada soalan?
Very much for everything. InsyaAllah kita jumpa balik.
Alright. InsyaAllah you can do it. So I believe hopefully lah you get something out of that of this session yang kita buat ni, walaupun saya tak berapa pandai untuk nak menyampaikan to the extent secanggih orang lain yang lebih pandai daripada saya. Saya minta maaf lah kalau ada mistakes ataupun shortfalls of my delivery. So insyaAllah kalau kita jumpa lagi, janganlah tak tegur ya. Mungkin saya tak berapa nak kenal because kita tak nampak muka-muka kita kan. So tegur saya, insyaAllah kita kalau you bukan student lagi, we can sit down and have a tea, to talk about life ke apa-apa. Alright, so thank you so much guys.
Thank you,
Assalamualaikum.
Salam. Thank you to your
All the
wife
best.
also, Prof.
Waalaikumsalam. Thank you, doktor.
Salam. Thank you, doktor.
Thank you. Assalamualaikum.
Salam.
Nanti record saya bagi ya.